Good afternoon. The City of Joburg says an attempt by police with a warrant to arrest the city manager of the city, Floyd Brink, failed because of a spelling mistake on the documents that were to be used to detain him. It's understood he was going to be detained because the city had defied a court order to not switch off the water connection at a particular property. As a result, he was judged to be in contempt of court and was to be detained for a period of 30 days. The city says he's been treated unfairly and officials should not have gone to his home, but rather to his workplace. Adv Mark Morgan is the chair of the South African Board for Sheriffs. They, of course, implement court orders. Mr. Morgan, good afternoon to you, and thank you for your time. Firstly, when you have a simple spelling mistake on a warrant, in this case, instead of Brink, they have the word blink, is that enough to stop a whole process?
Good afternoon, Stephen, and good afternoon to your viewers. Thank you for having me today. Well, on that point, Stephen, quite poignant. Our courts have given judgments, various judgments, on how to interpret court orders, but that normally happens in the instance where the error is patently clear, and usually our court, in terms of the uniform rules of court, one would look at Uniform Rule 42 of the Uniform Rules of Court, and it tells you exactly what standard needs to be met, how the patent error needs to read, or how it needs to look. But in the case where it's minor typographical typo errors, in terms of you've forgotten a letter, or you've forgotten, or you've mismatched the ID numbers, our courts have been clear to say, you have to apply, or the official that is executing such an order has to apply their mind. It has to be a common sense approach that you follow. It has to be a business-like, in certain instances, approach that you follow. And a simple error in or a typo on the name, or a mixed match of the identity numbers, cannot render that court order unenforceable. More so, you also have to apply a purposive, or look at the contextual approach when you interpret a court order. So in such a case where there is ambiguity, or the person against whom the court order is being executed on is of the view, takes such a point to say my name has been misspelled, for example, then it would be on that office bearer who is tasked with enforcing the court order to go and look at the actual court order, the file, because the file is a public document, ascertain themselves as to who are the parties that took part in those proceedings. That is easily ascertainable. And if in those proceedings you find that in the public documents they're under oath, state in the affidavit the position of that person, for example, the court order, I'll use myself as an example, is granted against the chairperson of the South African Board for Sheriffs, the contempt of court order. Everyone knows. You go on the internet, you look who's the chairperson, it would give you Mark Morgan. So a simple misspelling of my name will not vindicate me from an enforcement of that order, or a mixed match, because there's no ambiguity. It's quite clear. The office is there, so one would have to still enforce the order. But if the parties believe, for example, there was a substantive or patent error, it's always a simple application that is brought back to court before the presiding judge for variation in terms of Rule 42. Sure. Of the Uniform Rules of Court. In the Magistrates Court, it would be Section 32, if I recall well, in terms of which you'd approach the court. And then you'd explain in the affidavit what error there was, and you'd ask for rectification of the error. It can't be a substantive or substantial amendment, because of the principle that once the court has given its order or judgment, it becomes functus. So it can never now substantially amend the order that it gives, but only vary it in the obvious patent cases. Okay,
so in this case, from what you're saying, they could have just gone ahead with the arrest, except that they didn't. And, what does that tell us about the sheriffs who had to enforce this order? If they should have gone ahead, and if that's what you're saying, and they didn't, could they maybe have been flummoxed? Could they have been confused? Could someone have sort of fired a lot of legal Latin at them, and so they decided to go away and come back?
Yeah, it's a possibility. It happens because a sheriff is an officer of the court. Sheriff's first and utmost duty is towards the court, which is to enforce and execute on court orders. Giving one a benefit of the doubt, it happens that the sheriff may be human in certain instances. And though not desirable, and though should not be the case, if it isn't the case where the sheriff has limited knowledge in terms of executing the order and they have such doubts, which should not exist. I mean, in the ideal world, in the perfect world, in most countries, sheriffs are appointed amongst the ranks of lawyers, or they have a legal qualification. So one would be able to ascertain with the legal qualification, you'd know that, I mean, in such cases where the error is not that substantial, you can go on to enforce, and if you were to be sued, it is a proper defense that one can take, which a court will recognize and not hold you liable for enforcing the court order. But in cases where a sheriff does so and the person believes, or the public or the judgment executor believes that the sheriff is not thinking right, there is recourse that is available, and that's the South African court for sheriffs. A simple filling in of a complaint form, sending it to us if it's an urgent matter, then a directive would be given to the sheriff before the judgment executor can exercise their further rights to approaching a court for a variation order, simply because we understand and we provide this such assistance to try and curb the legal expenses, bearing in mind that it is a costly exercise to go and litigate and to always go and approach a court for even a simple application such as a variation order.
The other thing, I mean, the City of Joburg was quite frustrated that officials went to the home, they went to the private home of Floyd Brink, the city manager. They make the point that his minor children were there, for example. Is it common practice? I mean, they're saying that he could have been detained at his workplace and that would have been better. Is it common to go to a home?
I think there could have been a conflation of issues, Stephen. And I say so because there's a difference when you serve a notice or a court process that is to come under the notice of whomever is intended to be served on. And there's a difference when you execute a court order where a court says go and arrest a person and deliver them at a particular correctional facility in order for them to serve a sentence for contempt of court which they've been found guilty for. In the first instance that I've given to you, it's just by way of notice. So the normal stock standard would be if a person issues a summons against you or any other person or me, it would, in terms of the uniform rules of court, Rule 4, if it's a high court matter, for example, service sometimes is sufficient by just delivering at the work address, and it would depend, or at the person's residential address if it relates to their personal affairs, at a person who looks or appears to be 16 years or older. Certain instances, it doesn't even have to be the person, but there are instances where the proceedings that are brought are of such a nature that the service that has to be effected is prescribed by law. For example, in divorce proceedings, if my wife decides to issue a divorce summons against me, it cannot be dropped off with the receptionist at my workplace. It can't even be dropped off at home with the domestic worker. It would have to be served on me personally in order for the service to be effective and for the court to recognize or to acknowledge that I did indeed get notice of her intention to commence these proceedings. God forbid, it's just an example.
Yes.
But in other even sequestration proceedings, there our laws clear. It has to be personal service against the person whom you intend to sequestrate. And that is because such proceedings are sui generis, we call them. They are exceptional on their own and they alter person's status. And so that's service, as I've given. That's the daily work that sheriffs do. That action has no consequential effect. It doesn't have the effect of taking you to prison, for example. But where court orders or directs that a sheriff go and arrest a person, deliver them to a particular correctional facility, and then in order for them to serve a sentence that a court has imposed, that is instructive. And there is no prescription as to where it must be done. Wherever you locate the person, whether you locate the person at the workplace, whether it's at home, or whether it's at toilet in a shopping mall next to a Louis Vuitton shop, wherever you affect the arrest, that is the correct place where the person must be taken in or arrested and then taken into custody as per the court's directive. So there, in the second instance, the latter instance, location doesn't really matter. It's not prescribed as to where it ought to happen. And unfortunately, where court orders have to be enforced, in certain instances such as this, it's unfortunate where kids are there, they have to be enforced. It goes for any other lay person. If they were to be arrested, or an arrest warrant would have to be issued by a court for whatever reason. Maybe they didn't attend a bail hearing, or they didn't present themselves before court, then it would be anyway. And that's to vindicate what's right.
And Mr. Morgan, I mean, I've often seen threats in court, or people saying, we will have this official arrested if, on behalf of the City of Joburg or a ministry or whatever it is, they do the wrong thing, or that they're held in contempt. But I can't actually remember it happening. I can't remember it getting to the point that we saw today, where a sheriff has gone to the city manager of Joburg and said, you're in contempt, we're taking you for 30 days. And they didn't in the end. But I mean, it's very rare. Can you remember a case where an official from a municipality has been, where there's been an order to detain them like this?
Yeah. An official from a municipality, I haven't come across one recently. But a recent one that I think we all still have fresh in our minds was but this was not in the context of the sheriff. The court did not direct the sheriff, but directed the person himself to hand himself over to the police, failing which then the South African Police Service was directed to go and arrest the person and commit him to a correctional service. And that is the recent case of our former president. That's the perfect example where contempt of court proceedings happen. But remember, sheriffs as officers of the court, a court has the discretion of directing whom it thinks would be the best official to execute the order in light of the circumstances and the order granted at that particular point in time. So a court may decide the police. At certain instances, it may say the sheriff. In certain instances, for example, in eviction proceedings, it would say the sheriff assisted by the SAPS in the area. So it depends. But similarly here, it's seldom that sheriffs are granted or directed rather by the court to go and arrest people and then commit them to a correctional facility as well.
Advocate Mark Morgan, thank you, Chair of the South African Board for Sheriffs. I do appreciate the time. Well.